Hello friends, welcome to Unacademy. This is me, Dr. Siddharth Arora. Friends, this is an open secret that current affairs is a very crucial part of your civil service examination preparation. But you must draw a line as to what current affair you must study and which are the ones which you must ignore. There are certain current affairs which only have fun value, which only have time pass value. And there are other current affairs which can be very intricately connected to your actual syllabus for the civil service examination preparation. One of these current affairs I recently read was related to Mr. Arvind Kejriwal, the Chief Minister of Delhi, being summoned in a case of defamation for a social media tweet which he had only retweeted. Yes, you heard me right. That tweet did not originate from Kejriwal's Twitter account. He retweeted somebody else's tweet, which was apparently or allegedly defamatory in nature. Now, these are very crucial elements. The topics that we can study from here are: number one, the freedom of speech and expression; number two, the cause of defamation; number three, the role of social media; and number four, a very recent news related to the Law Commission of India are recommending that defamation should be included as a criminal offense also in the newly made Bharatiya Nyaya Sanhita. So there are many elements that you can study from this one small piece of news. Make sure that you watch this video till the very end, and I would suggest that you must make notes of these. These are very, very closely related to your examination. Make sure that you watch the last second of this video also. So before I start, a small introduction for those of you who do not know me. I'm Dr. Siddharth Arora. I'm a practicing advocate in the Supreme Court of India, and I have been also mentoring civil service aspirants on Unacademy over the last several years. I have been fortunate enough to have received the love, the respect, and the support of thousands and thousands and millions of subscribers as well as learners on Unacademy. I have been watched for more than 30 crore watch minutes on Unacademy, and SIDLIVE, SIDLIVE, is my referral code. Whenever you want to take an opportunity or the advantage of preparing for civil service examination through our platform on Unacademy, please use the code SIDLIVE and you will be getting huge discounts. For the topic today, let us start with a caution, in fact a practical warning for all our learners and everyone who's watching this video. We are living in the times of social media. We are living in those times when social media is a stark reality. It is no longer a time pass issue. It is something that we are mostly communicating through. So please make sure and also spread the message that beware of what you retweet. Yes, what you tweet certainly has far more emphasis to be placed on. However, the time has come that what you retweet, what you support, is also going to land you into trouble in case what you are tweeting or retweeting is a crime as per law. So make sure that you watch every step on social media. Remember, whatever is on internet becomes permanent. So with this warning, let us go and address the issue. So this is the piece of news that we read. So for those who are watching and more comfortable in Hindi, it says retweet पड़ा भारी 6 साल पुराने मामले में केजरीवाल को कोर्ट से झटका, मानहानि के मामले को रद्द करने से इनकार. Delhi High Court refuses to quash defamation against Arvind Kejriwal for retweeting. That is a very important point, and that is something that raises and place and provide such great standards of justice. As in, the Honorable High Court has also observed that since Mr. Kejriwal has large number of followers, even if you are retweeting, your message is spreading far and across, then you must be very responsible for what you are retweeting or what you are supporting, because the effect, however, is that if you are retweeting an offense or a defamatory remark, then the effect remains the same. This is going to be discussed across law platforms and judicial forums and social media platforms for many, many days to come. So let's first understand what are we discussing. So this is again the same thing. This is from Bar and Bench. Delhi High Court refuses to quash the criminal defamation case filed against Arvind Kejriwal for retweeting a video by YouTuber. High Court says Kejriwal has significant following and he did understand the repercussions of retweeting the video. And I quote, retweeting the defamatory content does amount to defamation. Something that all of you must now remember and take cognizance of. So let's first understand the why, the how, the what, the where, the who of defamation, also called as manahani. So you must understand each of these elements before you will be able to appreciate what defamation is. So first of all, for those of you who are absolutely uninitiated in the field of law, defamation in India is of two types. One is called as civil defamation and the other one is called as criminal defamation. In case of civil defamation, which obviously as the name suggests would be a civil case, at the end of the day, it would be mostly a case of a monetary compensation. There will be nothing more than a monetary compensation at the end of the day, right? However, in case of criminal defamation, the one which we are more bothered about, along with many other compensations and fines, etc., there could be a possibility of jail time also. So herein lies the main difference between civil defamation and criminal defamation. As of today, right, as the problem that we are now suggesting, okay, the ones which is more in news is about criminal defamation. So where do we see criminal defamation? So I have with me section 499 of Indian Penal Code, IPC 1860. Now, the point here is, and most of you must be wondering why am I showing IPC? Because Bharatiya Nyaya Sanhita as of now does not actually have defamation as an offense. Yes, there could be some shades of defamatory portions in those various sections. However, that is the fag end of today's video, wherein the Law Commission has actually recommended that defamation in its truest sense must also be included in Bharatiya Nyaya Sanhita. But for the time being, let's look at what defamation stood for, at least till such time that IPC was enforced. IPC defines 499. Section 499 says, whoever by words either spoken or intended to be read or by signs or by visible representation makes or publishes any imputation concerning any person intending to harm or knowing or having reason to believe that such imputation will harm the reputation of such a person is said to have defamed the person. There are many exceptions given, there are many explanations given. However, you are not law students and most of our audience would not be interested in the intricacies of the legal interpretations as given in section 499. However, kindly mark a few words. First, that defamation can be caused by words, either spoken or written words, even by signs, even by visible representations, be it in the form of a cartoon, in the form of an article, be it in the form of a joke, knowing that whatever remark that I am making is going to harm the reputation of that person. This is very important. There are two elements. One, the one who is making such a remark must be knowing that he has reasons to believe that such an imputation, such an allegation, such a remark that I am making, it could be an allegation, it could be an ilzam as it is said, for it is going to hurt the reputation of the other person. Yes, there are exceptions, but in most cases, this is the long and short of the story. Section 500 of the same code, IPC 1860, actually also provided for the sentence. So 499 describes defamation, 500 provides for the punishment of it. It says, there shall be a simple imprisonment for a term which may extend to 2 years or with fine or with both. So maximum punishment that is possible in this is simple imprisonment for a period of 2 years along with fine or the both of them. So section 499 and section 500 are the relevant sections of IPC which dealt with defamation. So just for the short brevity or brief summarization of the entire thing, whoever by words etc., which I've just read it, the crucial parts are the ones which have been highlighted in red color. The imputation will harm the reputation of such a person is the crux of this law. सिमिलरली इन हिंदी, उस व्यक्ति को बदनाम करने के लिए, ऐसे व्यक्ति की प्रतिष्ठा को नुकसान होगा, ये दिस इज द क्रक्स ऑफ इट. The sine qua non is one, you must be knowing or your reasons to believe that yes, whatever allegations that I'm making would be false. It will hurt the reputation of the person that is concerned with. So this is not new. This has happened in the past also. 2018, Mr. Arvind Kejriwal also landed in trouble with another matters related to defamation. This time it was the opposite person was Mr. Arun Jaitley, our late Mr. Arun Jaitley, who actually went to the court against Mr. Arvind Kejriwal, filing a defamation case against him. 2018 saw at the end of a protracted legal battle, Mr. Arvind Kejriwal said sorry to Arun Jaitley and he wrote an apology letter, which is right on your screen. You could read. In other words, the purpose of me showing this slide is that it is not necessary that all cases will end into some kind of monetary compensation or a jail time or a fine or either of them. It can be compromised also, provided the one who is making such an imputation would say sorry and the one against whom such an imputation was done, whose reputation came to be damaged, would accept such an apology. So this is also a possibility in any kind of defamation case. So now recently, there have been law commission recommendations on defamation. Now before I understand what are the elements of defamation, there are certain facts that you must all be well aware of. So this is also a recent current affair. It says 22nd Law Commission of India submitted report number 285 titled, and I quote, the law of criminal defamation to the government of India. भारत के 22वें कानून आयोग ने भारत सरकार को द लॉ ऑफ क्रिमिनल डिफेमेशन नामक रिपोर्ट संख्या 285 प्रस्तुत की. What does this mean? So what is the government asking? So the government is asking the law commission to recommend that since we have recently formed the new criminal laws, the new criminal procedure codes and the new apparently the alternative to Indian Evidence Act, should we or should we not include defamation as an offense in Bharatiya Nyaya Sanhita? That's actually the crucial element. So if you remember, Indian Penal Code 1860 is now Bharatiya Nyaya Sanhita Act of 2023 with recommendations, with amendments. Code of Criminal Procedure Code 1973, which is CRPC 1973, is now Bharatiya Nagarik Suraksha Samhita or Act of 2023. And similarly, the Indian Evidence Act 1872 is now Bharatiya Sakshya Act of 2023. Now, the recommendations is very crucial. So, this is something that you should understand. That many a times if the government is stuck with the fact or the government is not able to decide what kind of law should be brought into force, then the Law Commission has the power to provide with recommendations. Of course, they will do it on the basis of extensive studies analyzing the history of laws, the relationship with the existing articles of the Constitution and the existing laws and the international experiences, the various judgments of the various Supreme Courts, be it in US, be it in Australia, Europe, etc. Also the UDHRs of the United Nations organizations and whatnot. So Ministry of Law Justice has asked the Law Commission to study about the defamation laws and then provide recommendations on the basis of which the government will finally take a call whether to or whether not to include defamation as a criminal offense in the Bharatiya Nyaya Sanhita. Now, the crucial point and something that must be striking you again and again, and this is my position, that why are we actually talking so much about this part? So if you understand what is the problem behind all this, why are we discussing so much? Is there anything that I am missing or probably you are missing? Why is there such a talk about defamation as an offense to be included or not to be included? Is there an obstacle? Is there an issue? Is there a larger issue that needs to be discussed? Yes, there is. So first of all, it would do us a world of good that you read these words again of section 499 IPC, which was talking about defamation. Please read the words. And the word says, whoever by words either spoken or intended to be read or by signs or by visible representation makes or publishes any imputation, etc., 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 will harm the reputation of a person, then we will hold you guilty or at least charge you with defamation under section 499 IPC and to be punished under section 500 IPC. Pay close attention to what did I just say. Can I say that in a way, if I use my speech or expression, be it in words, be it in written words, be it by signs, representation, painting, jokes, whatnot, then there is a possibility that my speech or my expression might become a criminal offense or might be interpreted as a criminal offense. Yes. Now, this is one part of the story. So, let's cut this argument the other way. So, this argument is going to cut the other way. In other words, you have freedom of speech and expression. Yes, we have freedom of speech and expression under Article 19 of the Constitution of India. It is our fundamental right. It says all citizens shall have the right to freedom of speech and expression. Now, please look at the crux of the arguments over here. Understand what is it translating into. There is a constitutional article called Article 19. It provides you with freedom of speech and expression. Point number one. Point number two is that there is an offense under Indian Penal Code, which is Section 499 to be read with Section 500, which says that you cannot use your freedom of speech and expression to the extent that you are going to cause an imputation to a person which is going to harm his reputation. Now that means Article 19 subclause 1, which is subclause A, which is giving me freedom of speech and expression, is not an unlimited right. And this brings us to point number 3. If I look at Article 19 subclause 2, just pay attention to the point where the pink arrow touches. In other words, you cannot use your freedom of speech and expression to cause defamation. This is written in Article 19 subclause 2. Now connect the 3 dots. Article 19 subclause 1 is giving you freedom of speech and expression. Article 19 subclause 2 is saying you cannot use your freedom of speech and expression to cause defamation. In other words, it forms a reasonable ground of restriction. And number 3 are Section 499 and Section 500, which makes causing defamation into a punishable offense. Which, in other words, if I mix the 3 of them, I can actually say that the law of defamation is actually a gray area, or at least a shade, or at least touching, fringing upon my freedom of speech and expression under Article 19 of the Constitution. I hope the 3 dots are now connected to one another. Furthermore, the issue over here is that if I believe that there is an Article 19 and if I cherish my freedom under Article 19 of freedom of speech and expression, but I also have to ensure that the reputation of the person against whom I'm speaking or making a sign or a representation, his reputation is not harmed. I have to come to a balancing point. So this is the entire element in our constitution. Our entire constitution, our entire legal system is based upon maintaining a balance. This is the entire idea that we subscribe to. This is the point of view of the founding fathers of the constitution. Yes, we have to come to a balancing point wherein, for example, in this instance, we have to exercise our freedom of speech and expression, but we have to exercise the freedom of speech and expression very, very responsibly. So, it has already been understood. The Honorable High Court has decided in plethora of judgments that the right of reputation is considered as a part of Article 21. That is the one which says no person shall be deprived of his life or personal liberty except according to procedure established by law. Now you have many characters in this story. The first character is Article 19, which is giving you freedom of speech and expression. Second character, the second part of the story, hinges upon Article 19 subclause 2, which says that defamation is a reasonable ground of restriction. You cannot use freedom of speech and expression with relationship to the concept of causing defamation. Part number 3 of the story is right on the front of you, right? You can read this now. Article 21 actually guarantees you right to reputation. So till now we are dealing with only the fundamental rights. And number 4 is Section 499 and Section 500 IPC, which is dealing with defamation as an offense. So we have to balance 4 elements. And now you know what is the merit in sending this question to the court of or to the ball to let the ball be rolled through recommendations of the law commission, because these are not simple questions to answer. Although in the past, in the Subramaniam Swamy versus Union of India 2016 case, the Supreme Court was seized with this question, that does defamation consist of all the provisions which could be held as constitutionally valid, or are they not? In other words, the legality of criminal defamation legislation was brought to the notice of the Supreme Court, and the Supreme Court held it vehemently, absolutely, without a second doubt, that yes, these laws, Section 499 and 500, are absolutely fine on a constitutional standpoint and will pass the legal muster. So, we are now in a very major combinations of things. The Supreme Court has said that 499 and 500 is legal. We understand that defamation is an offense, but it does have a gray area, it does have a bearing on Article 19. Article 19 subclause 2 says that defamation is a reasonable ground of restriction, does not mean that your freedom of speech and expression can extend to the point of hurting somebody's reputation. And Article 21 says that right to reputation is a part of right to life as guaranteed under Article 21. So you have many combinations of many permutations and combinations, and each of them need to be resolved. So the problem over here is that at the end of it, the commission has recommended, yes, we must have criminal defamation, and this criminal defamation must be connected to country's criminal laws. In other words, you must be providing this in Bharatiya Nyaya Sanhita as it emanates from Article 21 of the Constitution of India. So, right to reputation is provided, guaranteed under Article 21. Hence, defamation does have a place in our legislations, in our criminal laws, and all of this should be done by maintaining a balance. So, I hope you have understood. In a very limited period of time, I have been able to explain. There are so many elements from one small piece of news, and then you can connect everything. And all of the discussion that I just did for you were all part of your UPSC Civil Service Examination syllabus. I did not deviate, I did not take a step, 1 inch of a step outside the four walls of your syllabus, and that is how you must study for your examination. These are the various offerings which Unacademy has brought for you. Foundation batch for IAS IPS 2025, the online classroom program for CSE 2025, and a very amazing offer of 50% off on your UPSC CSE subscription. You can save as much as 40,000 rupees on your CSE preparation. Use my code SIDLIVE, SIDLIVE, to get all these advantages. In the words of Unacademy, let's crack it. Until next time, God bless, thank you, and Jai Hind.